So we are calling our final case, Lauren Burleigh versus James Burleigh, 1284, September term 2019. Are counsel ready to proceed?
Yes, we are. I am.
Yes.
Okay. Judge Nazarian, the case is ready to proceed.
All right. Thank you, Madam Clerk, and good morning, everybody. Although you're in your offices or somewhere nice, you're attending a session of the Court of Special Appeals this morning. As we're all aware, these arguments are being held remotely as a result of the COVID-19 emergency and in response to applicable executive orders enacted by Governor Hogan and administrative orders issued by Chief Judge Barbera. We appreciate your patience as we work through the logistics of these arguments. It's been pretty smooth so far this morning, but little hiccup here and there, and everybody's worked through it together, and we're grateful. Since we are new to this technology for oral argument, there may be little challenges. If you're experiencing any technical difficulty along the way, please just raise your hand, and we'll do the same if something happens to us. And if we get disconnected, which happened in the last argument very briefly, wait a minute or two, and then try to get back in. And if that doesn't work, we'll have the clerk will reach out to you, or we'll reconnect everybody somehow. But first instance, wait a second to let the technology calm down, and then try to get back in. So one difference for today's procedure is that, unlike in court, I'm not going to be keeping the time. The clerk will be. She will show you a card when you have 5 minutes remaining, 1 minute remaining, and when your time is up. Ms. Spurgeon, when your time is up, since you're the appellant, you can keep going, but you'll be into your rebuttal time, same as always. For both of you, if any of us continue to ask questions after your time's expired, you're free to answer those questions succinctly. We'll proceed today otherwise as oral arguments normally do. One other request is, when you are not speaking, please mute your microphone to eliminate background noise for the other side. And if while you're muted you experience any sort of technical problem, just raise your hand and we'll sort it out. So with that, Ms. Spurgeon.
Thank you, Your Honor. Good morning. I'd like to begin very briefly to address our concern in this matter that Mrs. Burleigh did not receive a fair and impartial trial. It's our position that the court's ruling and decisions were rooted in bias, and the court's predisposition that once litigation is over, the parties will follow his rules and everybody will get along. The court stated repeatedly throughout the trial that litigation made it difficult to co-parent and that this case should be settled. There's no question that litigation exacerbates parties' relationships, but it is not always the source of issues between the parties, and we believe that the court's predisposition that it was the only source colored the entire matter. I'd like to go to some of the specific issues, such as the court's decision to award joint legal custody to the parties.
Before you get too far down that path, can you help me understand? You say that the court had a bias and a predisposition, but I'm not really sure what you mean by that. In other words, was he biased against Ms. Burleigh specifically? Did he have a bias or a predisposition toward some of these outcomes, and that was going to be the decision no matter what the evidence was? Like, it's challenged by the fact that your entire section on this doesn't have any citation to the record. But
I can't hear, Your Honor.
Okay. My ability to get my brain around your position is challenged by the fact that your whole section does on the unfairness and partiality of the trial doesn't refer to the record at all. But before we even get to that, can you help me understand what the source, you say, of the bias is, or the nature of the bias?
Your Honor, first of all, I believe I made multiple references to the record. This was an 8-day trial. I couldn't quote, I have a limited number of pages, but clearly the record is clear that this judge has a predisposition that any dispute can be resolved once the litigation is over with. He says that repeatedly. He says that he even stopped the trial at one time to see if the parties could settle the case. He has his rules that he gives out, and he states repeatedly, the court will follow, the parties will follow my rules when this is over with. And I believe
Isn't that what a court does when it orders something? It orders and the parties have to follow that order.
I guess I'm not seeing where that is something different than typically happens in a trial.
I believe it is excessive in this particular case, Your Honor. And I cite multiple occasions where when my client, for example, was testifying and she challenged that, he basically cross-examined her for over 40 pages of the transcript. He was not just asking questions to clarify the factors or things like that. He was cross-examining her and challenging her. No question, every party should follow what the decisions the court makes. But there was a long history between these parties, and I think it's illustrative with the focus on the joint decision-making ability. My client testified at length that they'd never been able to communicate properly and never been able to reach decisions. And there was testimony on both sides that neither party had been able to reach decisions. Going back to Judge Nazarian's question about whether it was specific bias toward our client, I believe because she challenged him and said, no, I don't think we can do this, that was not something that he was happy to hear. I have opinions on other things as well, but obviously those opinions are not in the record. This was not an issue that was raised lightly, either at trial or in the appeal. And frankly, Your Honors, when I didn't try the case. When my partners were trying the case, they were really distraught over what was happening. And it was something, and I hear that a lot if I do an appeal for someone else, that, oh, this is really awful, this is unfair. I think certainly when I read the transcripts, this felt very different.
Well, again, maybe I'm just not following you, but put yourself in our shoes, okay? If we were to write an opinion that agreed with you that Mrs. Burleigh didn't receive a fair trial, what is it we would say in support of that? Would we say Judge Silkworth was biased against her? Would we say that Judge Silkworth viewed he was biased against anybody asking for sole legal custody?
I believe it's both, Your Honor, and I understand it's a quandary, and I really debated whether to even raise it as an issue. I think there are multiple substantive issues that the court can look at very seriously and reverse and remand Judge Silkworth's decision. And I think the remedy would be then what we're asking, if the court finds that it would be unfair for Ms. Burleigh to have another trial hearing in front of Judge Silkworth, that another judge should be asked to hear it on remand.
Did you ask Judge Silkworth to recuse himself at any point during the trial?
Twice. Well, not one. At one point, my partner, after about 3 days of trial, raised the issue, and I think the term that he used was that he was neutering his case. And then at another point, after his very, very lengthy questioning of our client, which was, frankly, in my perspective, over the top, my partner asked him to recuse himself, and he did not. We did not ask for a mistrial, but he did ask him to recuse himself, which is not a step that was taken lightly. I don't know that it's ever been done by anybody in our firms, based on these issues in the middle of trial. But I think, to me, reading the lengthy transcript, there was no smoking gun. It was something that unfolded over time when I was reading the cross-examination, the court's cross-examination of several of my clients, our party's witness, and particularly of our client, and the court's rulings. It was repeated, and it was very frustrating, I know, for my partners.
Okay, hold on.
If I could ask a question, what when your partner asked the judge to recuse himself, what was the basis? The cross-examination of your client, or was there other reasons given?
That my client, that was the pinnacle. It was what had been happening throughout the trial, and that my client did not feel like she was going to get a fair decision.
And what were the reasons? Because of the cross-examination of your client?
Yes.
And what else was that? Anything else? Or
well, there were, and I'm trying to remember the sequence, because I believe that was day 4 or 5, if I'm not mistaken. Certainly the examination of her father was the court's examination of her father was quite excessive. The rulings, I mean, there were multiple rulings. I'm not sure. I don't know. What my partner said to the court was that based on how things had been progressing, and in particular his lengthy questioning, the court, that she didn't feel like she was getting a fair trial.
See, the tension here is sort of between, you know, the arguments we get all the time in these cases that don't work, which are, you, appellate court, should come out, should read the facts, read the record, and come to a different result. And that's, I know that's not what you're asking, but in a way, you're trying to get to the same place. You're trying to get a new trial by saying, well, the trial judge was so biased, or, you know, conducted the trial in such a way that we didn't get a fair result. And so as we press on this, you know, what you keep saying is, well, she came away feeling like she wasn't going to get a good result from him, and yet the result is essentially the same result, with the exception of child support, which is the dollars are very different. It's essentially the same custody arrangement that was in place during the entire PL phase of this case, and it's a joint custody arrangement between two parents who are both found to be fit, who live not very far apart. And I can understand, you know, it happens all the time. You get parties who ask for sole legal or physical custody, and the court doesn't grant it, or vice versa. But to find, I guess I'm trying to figure out how it would be in a case like this. We would find that, you know, as a matter of law, she didn't get a fair trial because she didn't win sole legal custody.
Well, Your Honor, I think this sole legal custody is a good example of the court's predisposition against sole legal custody. And if I could get into the specifics on that issue, we're not asking the court to reverse this decision because the court was biased. We're asking the court to reverse it because of very specific decisions that the trial judge made that we believe are not based on evidence or were an abuse of discretion. The bias is something that we ask the court to, if the court is inclined to reverse it, then to consider, and Judge Stokworth is now retired, but to specifically state that it would be in both parties' best interest to have a new judge hear it on remand. But the joint custody issue was really one of the critical issues for our client. We understand the physical custody, and while we didn't agree with it, and we think there are reasons why that should be revisited as well, there was a long history of these parties not being able to make decisions together. There was the court cited, you know, and a classic example that arose as the case was pending was the educational needs of the party's son, Douglas. He was no longer being homeschooled. He was, because of some issues that my client was concerned about, she was the one who was homeschooling him. He was enrolled in public school. There was an effort to get an IEP. Mr. Burleigh, for reasons that actually were supported by the findings of Dr. Santoro, making decisions was extremely difficult. And when you look at the factors, and you know how the court, and this court described it in Taylor v. Taylor, it's not just an issue of can you communicate in a civil manner, but can you reach shared joint decisions? And these parties cannot. And that was, and in the courts.
I mean, okay, you know, if I were trying this case, if one of Judge Woodward or Judge Grafe were trying this case, we might agree with you. But there's an 8-day trial. You have a judge who oversees that. He walks through, I mean, the opinion has a discussion of the Taylor factors. You may disagree with how he analyzed them, but how do we get to a finding?
Well, number one, it was clear he didn't understand the court-appointed expert's testimony on Dr. Santoro. He found that he was not considering her testimony on fitness. But the focus of her testimony did not have to do with fitness. It had to do with the test results showing that Mr. Burleigh was someone who was unable to make decisions. And that was, and the court didn't even remember, there was this comment by the court, he didn't even remember that any testing had been done. More importantly, and clearly the court can, I understand, the court can just say, I don't believe Dr. Santoro. I believe it's beyond that he didn't believe her. It was that he didn't even understand that there was testing and that even though Dr. Santoro could not make a DSM finding on a diagnosis, the testing supported the evidence. More importantly,
let me stop you there. So that's
yes.
this is the struggle, right? So Dr. Santoro specifically makes a point of saying, I'm not diagnosing you.
Correct.
But you would like us to say that the testing shows that he has this diagnosis, and that the court was wrong to cut the custody decisions the way he cut
The
it.
testing didn't. So testing, she described it as traits. My concern is the judge didn't even remember that there was testing. He made that comment during the trial. More importantly, Mr. Burleigh offered his witness, his therapist, Dr. Stevens, as a fact witness, but Dr. Stevens was basically treated as an expert, even though he was offered as a fact witness. He was allowed to testify as to a diagnosis. He was offered his credentials and were described at great length, which can't help but influence the court. And he was repeatedly allowed to answer questions that called for hearsay testimony, things that Mr. Burleigh had testified to. To me, that is clear error, Your Honor, that he should never have been allowed to give expert testimony when he was never even offered or accepted as an expert witness. His credentials are admirable, and clearly it can't be. It had to have had influence on the court. We don't know, but it had to have influence on the court. The court didn't say one way or the other who he was relying on in making his decision, only that he wasn't accepting Dr. Santoro. The court also, and when he was making a decision on joint legal custody, he also demonstrated his bias when he was describing in great deal the issues that he had with Ms. Burleigh. I realize this is a difficult hurdle for us, but I think if we didn't have the legal issues such as Dr. Stevens, the issue about, and the other legal issue that we have, Your Honor, that I think is to me is reversible error, is when the court refused to allow the case to be reopened when there was evidence that Mr. Burleigh had accepted a new job before the final decision was made. That goes to physical custody issues, that goes to child support and alimony and attorney's fees issues. I don't know if the court recalls, there was a lengthy testimony during the trial focused on the issue of whether Mr. Burleigh had voluntarily impoverished himself. He testified he had just accepted a job, making $65,000 a year. He would have flexibility. His flexibility was one of the factors that the court based its decision on physical custody for, that, he would be able to take the children to school and take them to their homeschooling at Mrs. Burleigh's home. But subsequent to the trial, he accepted a job in an office in Hunt Valley that is back in the financial services industry, where he had in the past made between $250,000 and $400,000 a year.
Wasn't there a letter from his counsel basically saying he was going to be making the same amount of money? And given that, how was it an abuse of discretion for the trial court not to reopen the case?
Well, number one, I'm curious if it's really reopening it when he hadn't given his decision yet. But number two, a letter is not evidence. Our client had no opportunity. We know the job was in Hunt Valley, but we had no opportunity to know where he would physically be working.
Well, there's still an option to do a motion based on changed circumstances, right?
And that was done. Yes, our client did. We did file a motion, Your Honor, and the response was this letter from Mr. Burleigh's counsel, and we had no opportunity to determine whether what she was.
But I mean, now, a year later, or whatever the time frame is, if there's actual evidence that he's making more, there could be a motion filed, right?
Absolutely, no question. But well, we're going back. That's if he was making more at the time before the judge even rendered his decision, and he's working in a job. I mean, we can't go back and remedy the physical custody aspects of it, but we certainly, the court can, the trial court could certainly remedy the alimony and the child support and the attorney's fees award if in fact this was happening back at the time. I mean, there was no reason. This is a custody and child support case. There was no reason after an 8-day trial, when something really substantial arises before the decision is made, that the court couldn't take the time to reopen the case. The motion was before the court in June. The court didn't issue its decision until August. It's inconvenient, but this is a custody and child support case. This is something where the court has to take those extra steps, Your Honor, based on, what this court has said multiple times. And why the court didn't do it, we don't know. He didn't. He just said our motion was denied. Certainly, we could go back and do that, but we needed. But we shouldn't have been deprived of that opportunity to do it at that point, Your Honor. That could have made a major difference in the outcome. We don't know. I think.
Okay. Yeah. You've eaten into your rebuttal time a decent.
Oh.
How much does she have left?
She's 3 minutes in, so you have 2 minutes left of rebuttal.
I will reserve the rest. Thank you, Your Honors.
Mr. Donahue.
Good morning, Your Honors. May it please the court. My name is Thomas Donahue. I represent the appellee, Mr. James Burleigh. I'm not going to go over every point that I made in my brief. I do want to talk about a few, and I also want to respond to a few of the points that were just made, as well as a few of the points that were kind of expanded upon in appellant's reply. First, as to the issue of recusal and bias, as was just discussed and as is discussed in the reply, in the middle of trial, appellant's counsel did orally request that the trial judge recuse himself loosely, sort of on the basis of some type of unspecified bias. In her reply, appellant seems to have conceded that the issue of recusal was not preserved for appeal. Nonetheless, she is asking for remand and for a new trial judge to be assigned. We know from this court's, a series of this court's decisions, Conwell Law LLC v. Tongue, as well as Miller v. Kirkpatrick, that in order to preserve the issue of recusal for an appeal, a party must have timely filed a motion before the trial court.
Okay, but short of recusal, we could find that the court abused its discretion in making a lot of these decisions without it rising to the level of him having to recuse himself, right? I mean, they're not actually asking. I guess they're asking on remand, if we were to agree with them, for the case to be assigned to a new judge. But they're not appealing the denial of a recusal motion. They're saying that the trial was infected from start to finish with a predisposition and a bias against Mrs. Burleigh. So I don't know how much Conwell Law helps you.
There's the degree to which, though, and in Conwell, the parting point of that opinion gets to this notion that it's not how, we shouldn't deprive the trial court of the ability to make a decision regarding some type of very serious accusation that there's some improper bias. That's the parting point in Conwell. That's what I think is relevant here. We know also from Karanakis v. Cartwright that when a party is alleging bias, they must allege factually an extrajudicial personal source for that bias. There was none made at the time of trial when this bias issue was brought up. There was no extrajudicial personal source brought up or verbalized at that time. As a result, we don't believe that.
Counsel, can I interrupt you on that very point?
Yes.
Would a predisposition of a trial judge to always grant joint legal custody qualify under your understanding of the law that there has to be some extrajudicial source of this predisposition?
Well, I think that might qualify. If there were a situation where a best interest analysis regarding legal custody was completely ignored because a trial judge just simply has this predisposition that every case joint custody is appropriate, that would seem like that would be a factual circumstance where you could have an abuse of discretion there. I don't believe that that's at all what is going on here. I don't believe that's what happened in this case.
Well, I guess that's a point of clarification that I wanted to at least understand, because it seems to me, having been on the trial bench, that there was always rumors amongst the trial bar about this particular judge or that particular judge having a predisposition toward certain aspects of family law cases. And, obviously, most of those don't rise to the level of being reversible error. But at the same time, it is disturbing to me if a trial judge takes an active role in the questioning of witnesses, and during that questioning somehow displays that predisposition, then I think there may be some difficulty here, especially when one counsel says, "Judge, you're neutering my case." So I do have a concern about that.
And I do think that with respect to the questioning, Ms. Spurgeon has on appeal characterized the questioning one way. What we do know from what the trial court directed counsel at trial is that he didn't feel that, he felt that I think a lot of questions being asked by, potentially both sides weren't getting to the relevant information. I discussed this point in my brief. He directed both counsel to, make sure that the questions that were being asked were, geared toward eliciting relevant information. I think that that's what he was trying to do over this entire 8-day period.
Well, wouldn't you agree with me, at least in my brief review of the transcript, that the trial judge did play an active role in the questioning of witnesses, did play an active role in sua sponte, calling counsel up to the bench to inquire as to the relevance of certain testimony, even though there had not been an objection?
I do, Your Honor. I do agree with you there. I do think that is within his discretion and authority to do. With that, I would just like to jump onto my next point regarding legal custody. I just want to preface by saying that the trial court spent 8 days on this matter, heard from approximately 14 witnesses. There were nearly 100 exhibits from both sides, including a couple of joint exhibits. The 35-page opinion included a best interest analysis that applied the facts of the case to the Taylor factors. There were not clearly erroneous findings that his decisions were based off of, and the decision as a whole should be affirmed.
What about the contention that your client's expert, the court, although the expert was admitted as a fact witness, the court asked for opinions, and appellant says that was improper? What's your response to that?
Well, as I discussed in my brief, and I think it's important to recognize that early on that there was kind of a recognized issue that there might be a problem with this witness, as appellant's counsel had made some comments that there could be an issue down the line. This is all on the record. Appellant's counsel at trial actually did not cross-examine, direct examined Dr. Santoro, the court-appointed psychologist, using Dr. Andrews' notes. That was their appellant's counsel's litigation strategy, I guess, moving forward to potentially try to water down later testimony. But Dr. Andrews' expertise was not actually an issue until during the examination of Dr. Santoro. Mr. Brown was examining Dr. Andrews was examining Dr. Santoro using Dr. Andrews' notes. I think that
how does that make it permissible for the court to allow this expert who was introduced as a fact witness to give an expert opinion?
Well, I think Mr. Brown's actions led directly to the expertise of Dr. Andrews being at issue. They opened the door through, using his notes during the examination of Dr. Santoro. And I think what I wanted to focus on
were his notes, if you could clarify for me, were the notes that they used factual issues or opinions?
They were primarily factual issues, but there, again, you have this situation where you're
how does that open the door then to expert opinions if they just use the facts?
Well, I think there were factual issues that are, you have essentially a hybrid witness here who is a fact witness who has expertise in this area. And, to the extent that those things are intertwined and certain questions that were asked by Mr. Brown, either directly invoke both the expertise and the, factual understanding of Dr. Andrews, they're somewhat linked to that degree. But what I wanted to really focus on, what I tried to focus on in my brief, is the fact that even if there was an error here, there was only harmless error. As this court knows, in order to find an error, there must be prejudice suffered by the appellant. Here, an error in this context is defined as, or prejudice is defined as an error that impacts or influences the outcome of the case. Appellant has not made a showing of that here. She did not make a showing of it in her principal brief. She, in her reply brief, attempts to walk through a number of aspects of Dr. Andrews' testimony that were allegedly prejudicial. I would have responded to those in my principal brief had they been brought up at that time. I would like to just very quickly get to the fact that every aspect that they claim was prejudicial to the appellant here was otherwise before the court through other testimony of other witnesses. And if you look at their reply on pages 6 to 7, you see sort of a litany of these aspects of the testimony. I just want to very quickly run through where you can find that all of these facts were otherwise before the trial court. With respect to appellant's actions during litigation, that was uncited in the reply, but Defense Exhibits P, which is Extract 2922, and then Defense Exhibits N, O, D, and Z. With respect to alienation, which they cited to Extract 1485, Exhibits C, D, and E, which is Extract 2873 to 2877. Appellee's involvement in homeschooling. We heard extensive testimony from the party's babysitter, Callie Woodcock, regarding that. And that was extract pages 1678 to 1679. Regarding the CPS investigation, 1488 is what they cite. You can look at appellee's testimony, which was 1774. And then I apologize for rattling these off, but I'd like to get them in. Appellee's emotional demeanor, which they cited as 1491. You can look at appellee's testimony, which was page 439 to 441. And then lastly, appellee's drug and alcohol use, which they cited to 1502. The drug testing results are found at 2503 to 2505, as well as appellee's own testimony, which was 1724. And I just would like to quickly move on to, and I'm not sure how much time I have here. I haven't seen a note card yet. But
I'm sorry, the 5-minute card will go up at 12:05.
At 12:05. Okay, great. Thank you.
Left.
Okay. So I did want to just jump ahead to the issue of voluntary impoverishment. As this court is aware, a party voluntarily impoverishes themselves when they make the free and conscious decision to, unrestrained by outside conditions, to render themselves without adequate financial resources. The trial court here heard extensive testimony from appellee regarding the circumstances surrounding his termination, as well as saw extensive documentation about his efforts after that termination to obtain new employment.
Okay.
The trial court.
What about the point after the evidence closed, he got a new job in the financial sector, and the court refused to take evidence on that, and especially to the extent it bears on not only his income, but and the resulting child support award, but it bears on physical custody.
Well, I think that
I realize I'm jumping ahead a little bit, but I don't want to run out of time before we get to this, because
that's no problem. So there was. Sorry.
It seems like a real problem. I mean, even if we were to agree with you that the court's finding that he didn't voluntarily impoverish himself is a reasonable decision under the uncertain circumstances. That fact didn't even survive the time before the court issued its opinion. And now he's gotten back into the space that he wanted to be in that was more lucrative, but even more to the point, he's commuting from Annapolis to Anne Arundel County to Hunt Valley after pitching his local flexibility and his his ability to continue participating in the lives of the kids. Help me with that part.
Yeah, and this was addressed during the summer between correspondence between counsel.
I know, but a letter from a lawyer is not evidence. So,
correct.
So to the extent that they asked for the case to be reopened so that this could get aired out, you responded, that's fine, but the court rejected, basically refused to hear anything of it based on a letter. So we know that the premises of the opinion that he's issued are not correct. Even before
there was a verified response that was filed to their motion, in which it was stated that it was verified, it was under oath there, that he would be making the same amount of money, that his flexibility would not be changing, and that his ability to care for the children would not change either. To the extent,
how is that possible?
How is it possible that, he just obtained a new job?
We maybe don't know a lot about what he's going to make in a commission-based financial services arrangement, but how is it possible that he can be available and flexible to take care of the kids when he's in this new job that requires him to commute 40 miles in each direction around the Beltway through terrible traffic and all that?
Yeah, well, to the extent there, and it was laid out both in the letter as well as in the verified response, that the job would be primarily and predominantly remote. It is my belief and recollection of that. And that was obviously always a pushing point for him as far as what jobs he was going to be willing to take, because he wants to be there for his children. So that was brought up in the verified response. It was also brought up in the letter to counsel. To the extent that neither of those were evidence at trial, surely that is correct, because these events all took place after.
Right. But it locked. No, of course. It wasn't possible to put on testimony during the trial about this. But the question is whether, this important set of facts bearing on child support, bearing on physical custody, bearing on a number of the issues the court's deciding. We know that before the court issued its oral or written opinions in this case, that the premises of the opinion it was about to issue are wrong. And so we're not faulting the court for lacking clairvoyance during the trial, but we can, I think, wonder whether it was an abuse of discretion not to account for this when you're locking in. This is the initial divorce case, right? So we're locking in custody, we're locking in child support, we're locking in all these things, putting back onto the other side a burden that starts with the burden of proving material change in circumstances to change anything. And so you're essentially bringing forward all this information, right, without having it aired out in advance of the decision.
Well, I think to the degree that it's discretionary and the judge sees from the face of the motion that even what's being just factually alleged wouldn't rise to the level of material change in circumstance, that decision is discretionary by the trial court. I think there's certainly some judicial efficiency involved with the judge having the discretion to say, we don't need to reopen this based on these facts. The order will be, in place. Ultimately, if my recollection is correct, I think that the ultimate order was in place probably around 4 or 6 weeks maybe after this issue came up. But again, after that order is in place, as soon as there is a material change in circumstance, that's when the appellant is able to go back to the court on some type of, and there's a responsibility of the appellee to.
So you're not going to be arguing then when that motion gets filed, right? You're not going to be arguing, oh, see, he's still in the same job, so there's no change of employment, so that's not a material change in circumstances, right? You're not going to argue that?
Wait, I'm sorry. I don't think I'm following the question.
Let me try again. When she files a motion, so if we agree with you and we affirm this decision, and the day after that comes out, she files a motion to alter custody or child support or whatever she wants to alter, and says, see, he changed employment and now he's commuting and now he's making more money. You're not going to be arguing, oh, there's no material change in circumstances. He's in the same job he was in at the time the court issued its opinion.
I don't know if that would be the basis of the material change in circumstance, the job itself. I mean, obviously, if his salary was drastically increasing to the point where it was affecting child support.
But you see the catch-22, right? This opinion locks in the starting point for all of these, right? And so when, the importance of getting it right, I mean, of course, in family law, anything can be modified down the road. But this is an important set of decision points, right? Because this locks in the status quo and puts the burden on anybody who wants to change anything first to prove a material change in circumstances. In this instance, you have a whole trial that's based on him having lost a job. He's now he's selling fleet trucks and he's making a whole lot less money. And the decision that results locks in all of these premises about his professional life and his income that are by the time the decision comes out are not true, right? And so they say, well, Your Honor, we would like to put on evidence that brings all of this information up to date. So when you make your decision about custody and about child support and all the things that are affected by this, you make it based on the right set of facts around his employment. And you said, no, don't do that. No need to do that because nothing's changed. We don't know how much he's going to make and all that. So then court issues its opinion. And you said, oh no, we should affirm that because those are all good decisions. Then sort of the catch-22 is when they after we affirm this decision and they move to modify, you're going to say, oh, well, see, he was in this financial job. He was working in Hunt Valley. Nothing's changed about his job or his circumstances. Maybe he's making a little more money. We can fight around the edges. But like all these things that could have been considered in the first decision, you're going to say, oh, well, see, nothing's changed since the court issued its decision last year. You see the catch-22? Now they have a burden of overcoming something that ended up getting baked into a decision based on facts that were not aired.
Right. And I mean, to the extent that those facts haven't changed and to the extent that down the line they motion with the court to change the circumstances because, the appellee starts making more money or he does get a job that's no longer remote and he's going to be driving to Baltimore. Those weren't the facts here. And those weren't the facts that Judge Silkworth was dealing with when he did.
Well, but those facts never got found, right? Those are there's a dispute about those. There's a dispute about what his job situation between trial and decision is. You say what you say, they say what they say. I don't know. I mean, but what we do know is that Judge Silkworth never resolved that. But so we have the opinion we have. If we affirm that, I mean, are you representing to me that you would, well, again, now, the challenge is that you're going to argue that nothing's changed because the court already decided everything based on his existing employment. And I'm trying to figure out how that's fair.
Well, I certainly think to the extent that something changes, there can be changes that are not material and would not result in any change in custody.
Right, but if this change in job had come 6 months after the decision, like 6 months after trial and after the decision, it's a pretty material change, or at least it's arguably material change.
Right? I would say that it's arguably a material change.
Okay, and that should get resolved by a court, not baked into a decision where that didn't get aired out, right?
If there's a factual showing in that motion that would rise to the level of a material change in circumstance, I would say yes.
Okay, but there never was a factual erring here. There never was a fact finding because it just got swept into the existing decision.
I don't think that what was presented in that motion would have risen to the degree of material change in circumstance. And like I said, it's, appellant would be free down the line to, if there does become some type of change that would rise to the factual level where she'd be able to carry that, then she could approach the court on that issue.
But if he's in the same job, your first argument is going to be he hasn't changed jobs, right?
Well, no, I think it would largely depend on what if he's in the same job, but he's now making, 3 times as much as he was making before, then yes, that would be a material change in circumstance, but you'd be at the same job. So it's not necessarily the job itself that would impact the
measuring point, in your view, would be Judge Silkworth's decision if we affirmed it.
I don't necessarily think that that's true. I think that it really has to do with the fact that that's a discretionary decision of the judge to make at the time.
No. I'm talking about when the motion gets filed. When the motion to modify gets filed, the starting point is going to be Judge Silkworth's decision if we affirm it, right?
Oh, yes, I'm sorry. I thought you meant his decision as to the specific motion.
No.
Yes, his memorandum of opinion would be,
So they would have to demonstrate a material change in circumstances from that opinion, from that decision, if we affirm it.
That in order to change some component, I believe that's correct.
Okay. Judge Woodward?
Well, let me follow up on Judge Nazarian's question, which is what I think the last interchange really focused on. Traditionally, when you have a motion to modify a judge's order regarding custody support, etc., the burden is on the movement to show change of material circumstances from the date of the order. And the question that seems to me is normally trial judges are told over and over again by the opponent of the motion, Judge, you can't go back behind or before the entry of that order. You can't go to any facts or circumstances that occurred beforehand. And I think the concern that Judge Nazarian is indicating and that I would share is that, are you going to say in such hypothetical motion to modify, assuming we affirm, in that motion to modify, are you going to say, Judge, you can't consider any facts or circumstances, namely this new job, that occurred before the judgment? Or will you allow Ms. Spurgeon to come in and say he changed his job, 2 months or 6 weeks before the final order, and that job involves these kind of circumstances? You see what I'm getting at? Will you take that position if I can force you into that position, or just what do you think about that?
I don't think that's, again, such a fact-heavy, it's such a fact-heavy analysis there that, it's not necessarily that switching a job would mean material change in circumstance.
No, but here's my question. Are you going to say to the judge, don't even consider the fact that he changed from the job with the Ford dealership to this financial services that occurred before the judgment? Judge, you can't consider that change. You can't consider what he did during that new job, his duties, his travel. You can't consider any of that because it occurred before the judgment was entered. If you take that position, then it makes Ms. Spurgeon's job almost impossible to show a change of circumstances based upon the change of the job and the change of the duties. Wouldn't you agree?
Well, again, I think that the circumstances that that will be part of the memorandum opinion, or that are part of the memorandum opinion, would have been the same circumstances, arguably. So you get to the point where if there's a material change in circumstances now, we'd be looking at the same fact circumstance as was laid out in the verified response.
So you would allow the court to look at facts that occurred before the entry of the judgment in assessing whether there was a material change in circumstances?
Well, the material change in circumstance would date back to presumably the memorandum opinion, which would
that's the point. That's the point.
Well, if I could clarify maybe what I'm hearing you saying, I'm hearing you saying that if there was a motion going forward, you would say what we're looking at for the circumstances, if he was making $65,000 a year and he was flexible with his schedule, if that changed, then there could be a material change of circumstance. If he made twice the amount and had to commute to Hunt Valley, it's not the fact of which job it is, it's what the ramifications of that job are. That's what would be the material change of circumstances. Is that your position?
I think that's what would impact the best interest analysis with respect to physical custody or legal custody and or support if we're dealing with salary issue. I think at the time that the court made the decision, it's a discretionary decision of his. And I don't think that there's any error there.
All right, let me give you a hypothetical. Granted, you had the verified that says that he's going to take this new job in the financial services area. And he was going to take that job before the entry of the judgment of absolute divorce in this particular case. And notwithstanding the fact that he said he would probably be making $65,000 per year in this new job, hypothetically, if when he actually got on the job and he actually started doing it prior to the entry of the judgment of absolute divorce, he began making $150,000 a year, or at a rate equal to $150,000 a year. And that rate continued. And then Ms. Spurgeon files a motion to modify, saying, Your Honor, he had the $65,000, now he's making $150,000, we need a change of child support. Would you be then arguing, Judge, there is no change in material circumstances because at the time of the judgment was entered, he was making $150,000, not $65,000, therefore there's no change?
No, I mean, if I'm understanding your question correctly, you're saying prior to the memorandum of opinion being answered, if he was actually making $150,000, but they got to the point where that motion had been denied and he was really, what was on record was him making $65,000, you would have a material change in circumstance in that example, if I'm following your question correctly.
Well, I mean, I'm saying that the facts that would show the material change of circumstance actually started to occur prior to the entry of the judgment of absolute divorce. That's the point that I'm trying to drive at, is that if, in fact, this new job showed that he was making a lot more as of the time of the entry of the judgment, most cases, the opponent of the motion would say, no, Judge, you can't look at that because that was before the entry of the judgment. You can only look at what occurred afterwards. And if what occurred afterwards was he made $150,000 and he was making $150,000 at the time of the judgment, even though the judgment was based on $65,000, there would be no material change in circumstance.
In that hypothetical, wouldn't the memorandum of opinion have been based on $65,000? Isn't that what
Correct. No, I absolutely. But the point is that trial judges are trained. This is beaten into our heads as trial judges. Don't go back behind the original judgment. It's a modification that occurs from the date of the original judgment, afterwards. So you're not the whole purpose behind it is you're not relitigating something. So, this would not be this case. But then again, there is that mindset that trial judges don't like to reinvent the wheel. They don't like to revisit something. And so many motions to modify, as you all know, you're experienced trial lawyers, so many motions to modify are really sometimes just a front or a facade for relitigating what happened before.
Right.
And so that's my concern is that the appellant is not going to be prejudiced by the fact that the court refused to look at the new job and the new job's terms and conditions, the new job's location, and all of those things that would play into support and custody, et cetera. That's all.
All right, Mr. Donahue, we dragged you a lot longer than your time allowed, so Ms. Spurgeon will be flexible with you if you have a little more than 3 minutes worth to say.
I have to unmute. I don't know if you want to give me too much time. This was a lengthy case, but regarding counsel's comments on Dr. Stevens, I think it's important that even if some of the things he testified to were addressed by other witnesses, he's still being treated and seen by the court as an expert. I mean, the fact that the court allowed lengthy testimony on his credentials can't help but have some influence and be viewed differently than what your friends are saying or what your family members might say about who you are. He's saying it's harmless error. Well, it's hard to prove a negative. He didn't say anywhere during his opinion, which witnesses he relied upon and which he didn't, other than the parties. He addressed their testimony at length and his rejection of Dr. Santoro's testimony. Other than that, he doesn't discuss who he's believing and who he doesn't believe. It can't help but have a different impact on any trier of fact that this is a man who has, good credentials as a therapist, and he's allowed to say repeatedly things that he would not have been allowed to say if he were strictly a fact witness. And I don't know that I need to beat a dead horse regarding what happened after the trial, but I certainly, if I were in Mr. Burleigh's attorney's shoes, I would certainly make that argument. I mean, that's what we hear, as your honors know, as trial, prior litigant lawyers and trial judges. That is always the first thing that any trial judge says, is we don't want to hear about anything that happened before. And Judge Silkworth knew about this new job. It wasn't something that he didn't know about, obviously. So I would urge the court to reverse this case and remand it, and on remand, for the reasons stated earlier, assign it to someone other than Judge Silkworth.
Ms. Spurgeon, let's say we agreed with you, for the sake of this hypothetical, only with regard to the abuse of discretion not to reopen testimony to deal with the new job. What decisions of Judge Silkworth does that require us to vacate? It probably reopens child support, right?
Correct.
Does it necessarily affect the custody rulings?
You mean his refusal to reopen the case? Yeah. I think the court should hear testimony on if it has an impact on physical custody, absolutely. Because the court went to great lengths stating, this is a family, they live near each other, he works from home. We don't know. We weren't given we don't know that. And we certainly, on a prima facie basis, it's a material change that we have the right to inquire about.
It doesn't bear on legal custody, does it?
Well, it bears on, only to the extent that these parties can't get along and communicate. This was not something, the testimony and the motion show, this was not something my client found out because Mr. Burleigh told her. She found this out through a third party or seeing something online. I mean, only to that, it's further evidence of their inability to communicate, Your Honor.
Okay. All right. Any other questions for these parties? All right. Thank you. The case is submitted.
Thank you, Your Honors.
Thank you, Your Honors.